I'm not a lawyer, but it was day 2 of the hearing that never happened in the YNW Melly trial. And as you probably could have guessed, the state did not turn over that search warrant. In fact, they instead filed a reconsideration motion, basically asking the judge to reconsider making them have to turn it over. In this motion, the state gives 12 reasons why they say that the judge should reconsider. One of the reasons is that according to them, they legally only have to say that yes, there is an ongoing investigation involving Raven Liberty, and anything beyond that, according to them, is not required by law. The state also says that making them provide a copy of the search warrant would greatly disrupt their ongoing investigation. They say it would reveal the names of other people involved, possibly allowing those people time to flee and or time to destroy potential evidence. And then in number 11, the state claims that even if Melly decides to waive this conflict issue and say that Raven Liberty can still be his attorney, despite the fact that she's under investigation, the state says that Raven would still have an ethical obligation to withdraw herself from this case. To support their argument, they cite a New York case from 2006 where a court held that if the activity for which the attorney is investigated is substantially related to charges against the defendant, disqualification is necessary, notwithstanding the defendant's waiver. So the state filed this motion at some point before today's hearing, but over objection, the judge ordered the state to turn over a copy of the search warrant.
Ms. Counsel, let me ask you this. I read your authority. Would you agree that they're entitled to a copy of just the search warrant, not the affidavit, just the search warrant?
At some point, but not at this point necessarily.
Well, can you explain that to me? Because if I sign a search warrant for someone's home and BSO goes to their home and executes the search warrant and they're there, they give them a copy of the search warrant.
Correct.
Upon its execution.
It's Apple that the warrant is being executed upon, not the party themselves.
And you think your authority says that she's not even entitled to a copy of the search warrant?
Yeah, that's correct, Judge, yes.
That's your position?
Yes, Judge.
Okay. Okay. Well, over the state's objection, I'm ordering you to turn over a copy of the search warrant. I'll put that in a written form today so you can litigate that as you see fit. But I certainly think she's entitled to a copy of the search warrant.
So we gonna see when and if they actually turn it over and if we, the public, actually get access to it. But for now, the next hearing has been scheduled for February 18th. Oh, and the judge also reemphasized that this trial will be happening in September.
So I don't know what else I can do at this point. You've asked me to press pause on all these motions. I'll press pause. I'm not going to move this trial date. This trial is going forward in September. So if these motions are heard next month, or they're heard in March, or they're heard in August, or they're heard contemporaneously during his trial, which again would not be the most ideal way to do things. If that's what ends up happening, that's what ends up happening. But the one thing I can tell you is not going to happen is someone that has been in custody for 2,160 days, his trial is not going to be delayed under any circumstance. So that being said, what else would you like me to do this morning?